Start. The Honorable Supreme Court in Bhoj Raj Garg versus Gowal Education and Welfare Society and others decided on 18 November 2022 has reiterated that the executing court is duty bound to conclude execution proceedings within 6 months in terms of Rahul S. Shah's case and that every possible efforts must be made to adhere to this strict timeline. Stop. The relevant portion of Bhoj Raj Garg's case is reproduced as under. Stop. This means that it becomes the duty of the execution court to dispose of the execution proceedings at the earliest, and since this court has directed that the execution court must dispose of the execution proceedings within 6 months from the date of filing, which can be extended only by recording reasons in writing for such delay. This direction is meant to be observed. Stop. This would mean that every effort should be made to dispose of the execution petition within the said time limit, and the execution court should have reasons for not being able to dispose of the execution petition. Stop. The execution court is duty bound to record reasons in writing when it is unable to dispose of the matter. Stop. The seeker of justice many a time has to take long circuitous routes both on account of hierarchy of courts and the procedural law. Stop. Such persons are and can be dragged till the last ladder of the said hierarchy for receiving justice. But even here, he only breathes fear of receiving the fruits of the justice of which he has been aspiring to receive. Stop. To reach this stage is in itself an achievement and satisfaction, as he by then has passed through a long, arduous journey of the procedure law with many hurdles, replica of mountain terrain with ridges and furrows. Stop. When he is ready to take the bite of that fruit, he has a pass through the same terrain of the procedural law in the execution proceedings. The morose is writ large on his face. Stop. What looked inevitable to him to receive it at his hands distance is diluted black into the horizon. Stop. The creation of the hierarchy of courts was for a reasonable objective for conferring greater satisfaction to the parties that errors, if any, by any of the lower courts under the scrutiny of a higher court be rectified, and long procedural laws also with good intention to exclude and filter out all unwanted who may be the cause of obstruction to such seeker in his journey to justice. Stop. But this obviously is one of the causes of delay, injustice. Stop. Of course, under this pattern, the party wrongfully gaining within permissible limits also stretches the litigation as much as possible. Stop. Thus, this has been the cause of anxiety and concern of various authorities, legislators, and courts. Stop. How to eliminate such a long consuming justice. Stop. We must confess that we have still to go a long way before true satisfaction in this regard is received. Stop. Even after one reaches the stage of final decree, he has to undergo a long distance by passing through the ordained procedure in the execution proceedings before he receives the bowl of justice. Stop.